your home office, but if it ends up not being, or if you have family or friends that are in other parts of California, we're able to continue serving people in person in other areas. With that, though, we can also do Zoom and calls. So if someone can't get to us or it's just not as convenient, we can also meet remotely. Now, one of the things you should have in front of you is a handout that has all of the slides we're going to go through today. One of the things we encourage is that you do take notes as we go, because this is a lot of information in a relatively short amount of time. A lot of what we cover today is very general. So the other thing to note is that as a result of being here, you are entitled to a complimentary consultation. So as things happen, as you have questions, just know that you can take advantage of that consultation, and we can then hone in on things more specifically for you. So let's get started. So first and foremost, foundations of estate planning. So this is going to be important for two reasons. One, for those of you who do not have estate planning, it is going to be important to know in this section what documents might you need. The reason that this is so important is it's not a one-size-fits-all, and it's generally not one document fits every need. So if you don't have a plan, today is where you get to learn what are the different components you will need. The second piece, though, is for those of you who do have an estate plan, it's going to be a reminder of why the documents you have are so important, but also why keeping them up to date is an imperative piece of your estate planning. Estate planning is not a one-time in life, and you get to put it on the shelf and be done forever. As your life changes, as the law changes, it is important to take those documents out and give them a once-over every so often to make sure they really are still correctly protecting you and the ones that you want to protect. So the first document that every person over 18 needs is an advanced healthcare directive. As soon as you turn 18, no one has an automatic right to make your medical decisions. Not a spouse, not a parent, not a child. So when you're 18, if you can't give verbal authorization for who can make those decisions, it needs to be in writing so that that is communicated on your behalf. Another few points. Having a comprehensive directive can be extremely beneficial. You can, for almost any of the things we talk about today, find online free options. But free equals cutting quality. And when it comes to the healthcare directive, one of the things that we do is we go through and ask you a series of questions about would you want life support under certain conditions? What about organ donation? These are things that, for two reasons, we want answered. One is it keeps you in the driver's seat, even if you can no longer control and actually verbally explain what your wishes would be. But the second reason is for the person who ends up in the position of actually having to make these decisions, to have had you already give that guidance ahead of time can take a huge amount of guilt, stress, and emotion off of them in a time that is likely already stressful and emotional, especially that life support question. So having a comprehensive healthcare directive is huge. But it is also important to know you need one that was done post-2004. If your directive was pre-2004, it does not have a HIPAA compliance statement that is required to be accepted. And so if you, again, have one pre-2004, physicians are not supposed to accept it. And so it is imperative that you get one done more recently. But again, making sure it is up to date with who is in that position for you. Relationships change, people pass away or move, things alter. And when you're in a vulnerable state where you need someone to make medical decisions for you, you want to make sure who is going to do that really is the correct person. So for all of the documents, we recommend coming in and seeing us every 3 to 5 years so that we can help review and confirm, is this still the right person and are they still the right decisions? If you have Kaiser and you have not seen us in the last, I'll say 18 months, maybe even just the last year, come in and see us now. Kaiser, it was a one-off, but one time was too many. They rejected the healthcare directive we had prepared because they said it wasn't specific enough for when the document would become active, which thankfully our client was in a position where he regained the ability to sign a new directive and answer the question Kaiser had. But we have now addressed that with what is called an addendum. What that means is it will answer the question Kaiser has without you needing to redo your full directive. If you don't have Kaiser, you can disregard it this time. But if you have Kaiser, come in and speak with us. It's quick, it's relatively inexpensive. If you're an Access member, it's free. So come in and see us so that we can get that done if you need it. The next document that is imperative to have is a financial power of attorney. This is again a document where if you can no longer make your own financial decisions, you are putting in effect who can do that on your behalf. Now, one of the things we often hear is, well, my spouse is on my account, why do I need this? Two reasons. One is they're not going to be on all of your accounts most likely. Retirement, annuities, life insurance, these are things we more often see be in one person's name as the sole owner. And so what that means is while your spouse may be a beneficiary, they don't have an automatic right to manage the asset if you become incapacitated and can't give that authority. So having in place that your spouse can manage anything for you can be a huge component of making sure the finances can still be used. The other thing is, what if you don't have a spouse or something happens to that spouse? You want to have a document in place that says who can take over if we are both incapacitated or, again, I don't have a spouse. So it is, again, important to make sure you have a successive list. The other piece is these need to be updated right now every 3 to 5 years. We're using the 5-year rule as more hard and fast. After COVID, financial institutions really responded to the incapacity issue by saying this document needs to be current. And what they have said is a 3 to 5 year standard. The reason that happened is, unfortunately, with a rise in incapacity, there was a rise in elder abuse and financial fraud. And so while this was not a law change, this was a financial policy change. And so more and more of our clients were having their documents rejected, and we were being told by the banks that they had to be done currently. So if you have not had yours updated in the last 5 years, again, now is the time to come in and see us. This next one is not universally needed, but it is extremely important if you fall into this category. If you are someone or know someone who may need a psychiatric healthcare facility, so this is not memory care or long-term care, this is truly focused on psychiatric. You need an additional healthcare directive to answer questions specifically pertaining to psychiatric mental health care. We had a client who had a healthcare directive but did not have this document, ended up having to be temporarily, thankfully, in a psychiatric facility where her power of attorney on the health side wasn't accepted. Once she was out of the facility and was able to come in and sign this, we were able to take care of it. But if you're in a position where this may be needed, you want to make sure it's done ahead of time so you don't end up being vulnerable like this client unfortunately was. One of the other huge issues with not having your healthcare directive or financial power of attorney is if you lose the ability to say who can do these things on your behalf or to sign these documents into effect, when you lose your capacity, the only place that is able to grant authority is the court, and that is through the form of a conservatorship. Conservatorships are a nightmare. Generally speaking, the person is vulnerable because they're incapacitated to an extent they no longer can legally sign something. They still need often medical care. They still need financial care. But until the court appoints somebody to do these things, no one is allowed to do it. So it can delay treatments, prescription refills, bills being paid, being able to be put to the right care facility, all of these nightmare scenarios that very easily could have been avoided with just those 2 documents. So if you take nothing else away from today, make sure you have an up-to-date healthcare directive and financial power of attorney. The next question we look to answer is, do you need a will or do you need a trust? Wills are used less frequently, especially in California, because California is extremely strict about what a will is able to cover and what it is not. If you do not own a piece of property, so you have no real estate, or you have less than $200 and about $9,000, a will may be enough to protect you or your estate. But if you do own a piece of property, or you have more than that dollar amount, a will is not what should be discussed. At that point, we really need to talk to you about a trust. The reason is if you have just a will, the court again has to step in after you've passed away and dictate what happens with your estate and who ultimately gets to inherit. So the control is stripped out of your hands at that point because you have passed away, and it's stripped out of the family's hands. The only place that gets to control it at that point is the court. Now, if you have a will, their job is to approve your will and then follow what it says. But it still is going to follow court rules and take court time, which if you have ever dealt with the court system, or frankly any government entity for the most part, they're not generally known for efficiency. And the court system is very, very impacted. And so even in the simplest of cases, a normal probate can take 2 to 5 years to get things settled and done, which means you're being dragged into court, no money can be distributed, and in some cases, beneficiaries will actually pass away during the process because it is so long. And so anytime the court is involved, it is the least optimal situation. The other issue is anytime court is involved, generally speaking, the cost is much higher because often you need more attorney involvement, the hours that are higher, and with probate sets the cost that the attorney is going to get. We actually don't set our own fee. So generally speaking, if you had a home that was valued at $1.4 million, not what your equity is, but what it is valued at, you can see a probate cost just shy of $60,000, and that's just for the home. And in Santa Cruz at this point, that is becoming more and more realistic for the house pricing that we see. So you can imagine, even if your house is valued lower, it's still an extremely high price point for probate at that time. If you're curious what probate would cost your estate without a trust, you can actually go to Copenbarger.com, and under the Resources tab, we have a probate calculator. You can put the number in and see what would probate cost you today, or your estate today, if you did no planning. But the great news is we can avoid all of these nightmares. So that is where we talk about trusts. So trusts are designed to essentially answer all of the questions that the court said a will would not. It answers who is going to manage in the event you no longer can due to incapacity or after you've passed away. It will address who gets to inherit, but it also allows you to address when the person inherits, how they inherit, can you add extra protections around the inheritance. Because just let's use a family that has 3 kids. Just because you have 3 children doesn't necessarily mean you want them to all inherit the same stuff, to inherit the same way, or to inherit at the same time. And so depending on the situation, your trust allows you to set the terms and really control how are things going to be done, rather than putting it in the court's hands where they just follow their rules and nobody really gets to say any differently. The other thing is with trusts, you can do tax planning. Now, a lot of times we hear people say, tax planning doesn't apply to me. I don't have an estate that is in the uber millions. Well, whether we like it or not, unfortunately, taxes, big and small, affect us and our estates. Most people say they don't like that. And so we're looking to avoid unnecessary taxes. We're going to talk a lot today about what some of those unnecessary taxes are and how they can be avoided. But with proper planning, most people are happy to know you don't have to pay the government, whether during life or death, any more than is legally required, which I have yet to meet a client say they want to pay an unnecessary tax. If you are that person, I'd love to meet you and ask why. Now, one of the other things that we see is people not coming into plan because they're not sure who they want to appoint as a manager, either when, again, they're incapacitated or after they're gone. You may have kids. It doesn't necessarily mean your kids are who you want in that position. You may not have kids, and you may not have a spouse. You may no longer have living relatives. When the pool starts to shrink for who we manage, it delays people wanting to come in because they don't feel like they have an answer to this question. 2 things to that. One, if you are stuck, if you are in that position where you're going, I have not moved forward because I don't know, come and still see us. One of our jobs is to help give you alternative ideas and suggestions to see what any of these alternatives answer the question we're looking to do. But the other thing where we answer this is we talk to you about what are called directed trustees or professional fiduciaries. Professional fiduciaries, they're professionals. They normally cost a little bit more, sometimes a lot bit more, but they have a job to do. They are someone, they come in, they wrap the estate up when you've passed away, they get the job done, end of story. They dot every I, they cross every T. But not many people want to necessarily have a professional fiduciary do everything. Maybe you're okay with someone else doing the finances, but what about cleaning out your house, going through your stuff, the more personal side? That's where we can talk about what are called directed trustees. In this case, you could appoint someone who would manage the money piece of it that may not be related, it likely won't be someone related, while also having somebody appointed as a co-trustee who can do the personal side of things. So if you are stuck, all this is trying to explain is we are here again to help guide you through alternative ideas and give you some scenarios that may end up answering these questions. I mentioned a minute ago that most of our clients are going to talk to you about having a trust. However, if you have a trust, you actually still need a will in place, but it is called a pour-over will. One of the things when you set up a trust is we should have instructed you to put certain assets into the name of the trust. Generally speaking, we take care of the real property, but real property needs to be in the name of the trust. Your checking accounts, savings accounts, and non-retirement investment accounts should actually have the trust on title of the actual asset. But some people forget to do this, they choose not to do this, and they pass away. And ordinarily, that asset would be subject to the entire probate process. But by using what is called a pour-over will, we are essentially able to go to the court and say, no, stop. You need to give it back to the client's trust. Administer it according to the trust terms, not according to the court's wishes or terms. And so again, yes, you should have a trust, but you will also have a will. If you are not sure if you have this will, we are more than happy to take a look. If you have one of our black portfolio binders, there should be a tab that says Last Will and Testament. If you have one with your trust tab, you have a pour-over will. Okay? Now, a lot of what we talk about is the financial component of making sure the assets are protected, of making sure that the assets go where you want them to go. But what about your stuff? Stuff is unfortunately one of the areas we see left unanswered, but that leaves a lot of complication, a lot of emotion, and unfortunately a lot of fighting. Stuff truly is where we see families often have argument, lose unrecoverable money fighting. It becomes a bit of a nightmare. How many of you have heard the Colander story at this point? I see a number of you. For those of you who haven't, one of our worst fights we had was between beneficiaries. There were 3 or 4 of them, where after Mom died, they all decided they really wanted her pasta colander. I think it was maybe $5, maybe a $5 plastic colander. But Mom had used it at every holiday, every special event. That was something that, for whatever reason, became Mom when she passed away. They all put an emotional attachment on it. Well, you can't really split colander 4 ways and still have it be effective. So what they did is all lawyered up and fought over this thing. $5 colander that cost thousands of dollars and caused a ton of strife within the family. Now, as silly as it is, one of the things we had put in Mom's trust was that she could have left a letter of instruction about that colander. She could have said, you all get to use at your birthdays and you have to come together and share it at the holidays. Now, while a custody agreement of a colander is an extreme example, what I really want to emphasize, though, is again, stuff has emotion. Whether people acknowledge it while you're alive or not, when someone passes, stuff becomes valuable in a way that you can't put a dollar amount on. And so if you have a Copenbarger trust, you have what is called a memorandum power. What that means is you can use a handwritten letter where you say what the item is, who it goes to, and you just need to sign and date it. If it's in your handwriting, you don't need a witness or a notary. But that allows you to leave items to someone specifically so that they get that thing. Instead of it leading to a fight, it becomes theirs. And while, again, we hear constantly people say, my kids don't want anything, I would argue that they don't want it because you're here. They still may not want it when you're gone, but again, more often than not, what we see is when the loved one is gone, all of a sudden that thing becomes the reminder and the tangible thing to hold on to. The other thing we encourage clients is if you have assets, items that have meaning, that have stories, that have family origin, write that down, put that somewhere that can be traced, because once a loved one passes, if that story has not been captured, it's gone. And so a lot of times, unfortunately, those valuable emotional components get lost after someone has passed. If you have any questions on how to do that, we're also happy to answer that for you. Now, digital assets. How many of you have a smartphone? I guess most. I've seen a couple people who don't. Most of us have, though, this smartphone that holds our lives. We no longer have a Rolodex or a contact book. Everything is in that phone. We no longer have printed photos where we're writing on the back of who's in them. They're on this phone. So unfortunately, what that can mean is when you pass away, if no one has the password, if no one is listed what's called your legacy contact on your phone, that entire database, that entire component can be lost. So two things. One is, if you are comfortable putting passwords in a secure place where someone can access them when you pass, that is one option for accessing the phone. The second thing I briefly just mentioned is called a legacy contact. You're in your settings and you click your little name icon, there is a way to set this legacy contact. What that means is it's someone you're authorizing after you pass away to access these accounts. So yes, you probably want it to be somebody that you trust. Not everything on the phone is necessarily wanting to be public knowledge, but it is again a way that someone can access contacts, which may be how they invite people to a funeral. It's how they can access photos for the memories. It's the new Rolodex, essentially. So if you have questions on that, we're also happy to help walk you through there. Cryptocurrency. So for anyone who has cryptocurrency, this is an asset that is not managed like your other assets. What that means is if you pass away and no one has your code, your key, your chain, that sequence of numbers or letters to access the actual asset, and you pass away, it is lost in almost all cases. It is an unrecoverable asset. So again, it is imperative to make sure that you put somewhere secure and safe that someone you trust or want to have that asset find it before you have passed away. Again, if you have any questions on that, we are happy to help. One thing you'll note, this little QR code. If you see a QR code on any of the slides, what that means is that we have a webinar about this topic in more depth. So, if we don't cover it enough today and you have further questions, and you see that QR code, all of the resources are free. Please feel free to use that or go to our YouTube channel where you will see all of our webinars that hit these topics in more depth. Okay, part two. So that was the foundation of estate planning. But as I mentioned, one of the things with estate planning is it is not a do it once and then never look at it again. As life changes, one of the things you want to make sure is that your estate plan is being kept up to date. Because life changes. When you started out, maybe you had no children, or you had minor children. Maybe now you have adult kids. You weren't married, now you are, or you were married and now you're not. Are you planning to leave the state, or less likely, are you someone moving into California? Most of our clients that we have are not new to California, they are looking to leave California. But are you planning to move? All of these are events that we recommend you come in and see us to, again, make sure things are really adequately protecting your current situation and the protections that we can predict for future needs. Before you move, so if you are planning to leave California, normally assets are changing. You may be selling your home here and buying a new one, closing bank accounts and opening up new ones. As stuff is shifting, one of the things that often gets forgotten is that you have a trust, and that these assets that you're acquiring in particular need to still be titled in the name of your trust. And so if you are in the process of moving or you're planning to, come and see us so that we can help remind you, okay, this is what you need to tell the title company. This is the document you need to give to the bank in this new state. That way, as things are shifting, you're making sure that the stuff you had set up maybe decades ago continues to be done correctly today. Like that picture? All right. Have you gotten married? Have you gotten divorced? These are huge elements that need to then be addressed in your estate plan if you already have one in existence. If you got married, sometimes you want your spouse to become a beneficiary and become a trustee, and you're going to do everything joint, but not in all cases. Sometimes you're not the first marriage, and so it's a blended family. Sometimes you want to keep assets separate. There are a variety of reasons that just because you got married doesn't necessarily mean you want everything to overlap. And so if you're in a marriage situation, though, we at a minimum need to identify that you have gotten married, and are you going to provide anything for that spouse or not? More importantly, we need to identify if the answer is not. So if you have, again, gotten married, come and see us. The other thing, if you've gotten married, is you have different trust options. So when you are a married couple, you have different options as far as what will happen when one of us passes away. In some options, the trust says, if I die, my husband can continue to manage anything, he gets the trust in full, he gets to set all the terms, do what he needs to with all of the assets, and off he goes. But in some cases, when the first spouse dies, people want what is called an A-B trust. What that essentially means is if I pass away, while I might want my spouse to be able to manage everything for himself, or to use the assets for his own care, I don't want him to change where mine would go. That when he dies, I want it to be locked in place that it would go to our child. Then, if he remarried, changing my half to going to a new spouse. So if that is a concern, that you want to lock down that half, that is something that we can discuss. And then on the reverse, have you gotten divorced? Well, in most cases, you don't want your now ex-spouse to still be named as your power of attorney, or to be named as your trustee, or to be named as your beneficiary. There's likely a reason that you divorced. And so again, if you've gone through that process, we want to make it clear who actually would manage for you and who would benefit when you are no longer here. What about your children? So, with minors, we set up what are called minors' trust protections, essentially looking to protect their inheritance until they reach an age you hope they will be mature. With minors, hitting 18 in and of itself is not indicative of maturity. So that's what we can do for minors. But what happens when they become adults and now they may have creditors of their own? What if they have debt issues, or they're in a car accident, or they go through a divorce? Do you want the inheritance you're leaving to be subject to those possible creditors, or do you want it insulated and protected? One of the things we can do is put in what is called a protective lifetime trust. What that essentially means is you get to decide if they're going to manage the inheritance or if someone else will, but essentially you're putting a wall around the inheritance. You are saying if they are in a car accident, if they have debt issues, if they go through a divorce, that the inheritance you left cannot be taken away by those financial creditors. So this is an additional protection that can be put in if it is something that is of concern. What if you have a beneficiary with a special need? So this is one of the categories we often see misunderstood. What a lot of people assume is if they leave an inheritance, the person will absolutely, in no question, lose government benefits, which is true if you leave an inheritance to someone without proper planning. But with proper planning, you can leave what is called a supplemental needs trust, where someone can still receive an inheritance, but it is not theirs. It is used to supplement what the government is not providing, which means you can still leave them something to, again, account for what the government isn't providing without triggering a loss of often crucially needed benefits. One of the things we unfortunately see is people trying to get around doing this trust by either not leaving money to that child or leaving it to the child's siblings with the hope that those siblings will take care of the one who needs it. You can probably tell by my face how often that sadly happens. We have had nightmare after nightmare where the parents had the best of intentions in doing that. They left it to the one child who said, yes, of course, Mom and Dad, I will take care of my sibling. And then the money is left, and legally, it is theirs. They have no legal obligation. And in a lot of cases, they do not. So again, making sure that an often vulnerable group is really protected is something that hits near and dear to our hearts. Again, you'll see a QR code here, so if you want more information on this, you can watch the video, or you can come in and speak with us more directly. But we do a ton here at Copenbarger. So beyond what we're talking about today, we have trusts up the wazoo here. We do planning for all of these different situations, and then some. I'm not sure if it's something we can help with. Or you see something and you go, oh, I did have questions about this. Again, use the complimentary consultation and come in and see us. The worst thing we'll tell you is you don't need it or we can't, but in most cases, we're able to tell you how we can help, what the cost will be, what the work involved will be, and make sure that anything you need protected really does get protected. Now, when you have changes, please, 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 do not just email us and say, these are my changes, these are now effective. An email is not enough. Do not start writing all over your documents. Don't start crossing people off and changing your distribution and writing all over it. Because one of two things can happen. One, you may lead just to confusion when you pass away that involves the court. But two, you may invalidate the full document at that point. Because with estate planning, changes have to be done in a valid way. Typically, this involves either witnessing or notarizing the document. And just writing over things can cut the important terms that were needed. It can, again, lead to confusion. And truly, we have in some cases seen it completely wipe that document out. You start changing the dates on things, and now you have 3 different versions that have different dates, and people are trying to question, okay, well, which one do we have to now follow when you've passed away? Again, it is better, cheaper, and safer to ask us the question and let us instruct you whether or not it's something you can do, or frankly, from a cost standpoint, it is in the long run more cost effective to do it right than try to save $1 today and often cost thousands in the future. So please, if you have any questions about changes, come and speak with us, because there are a few things clients are able to do on their own, but it is a very small group. So we would, again, much rather it be done correctly and not have these issues come up later than find out that there were problems when you no longer are here to fix them. All right, one more deep breath, and then let's go into legal changes. So everybody's favorite topic is legal changes. I'm being very sarcastic here because now we get to talk about taxes. But the good news here is when we're talking about taxes, a lot of what we want to emphasize is, again, how to cut unnecessary tax implications, especially when it comes to inheritance. There have been a ton of changes since 2020. If you have not seen us, if you have not been to a seminar, a lot of information is about to come your way. If you have been keeping up with us, some of this will be old news at this point, but there are still a few legal changes that it's going to be really important you are aware of. How many of you at this point have heard about Proposition 19? All right, good. We're getting more and more saying yes. The reason this is so important is Prop 19 fundamentally changed the inheritance advantages when it came to real property. And most people were not aware when this passed back in 2020 and was effective in 21, what that actually meant. When this proposition came forward, of course, they put all of the positives. Essentially, the positives are if you're over 55 and you're planning to move within the state of California, you can transfer your property tax in your lifetime. So if you're planning to move in California, that may be an advantage for you. But how many of us at over 55 years old are going to be moving, frankly, within California, but especially 3 times over the age of 55? Not many. And so unfortunately, the negative side of Prop 19 has been more of the impact we have seen, which has greatly restricted the benefit of somebody inheriting a property from you. The hard and fast rule now is when you pass away, if you have any secondary property, land, business, rentals, vacation home, and it goes to someone, it will be reassessed. Period, end of story. If they choose to keep it, the property tax base will go up. The only property that can keep your property tax base is your primary residence, but only if it goes to a child who also claims it as their primary residence. So if it goes to a child and they turn it into a rental, it goes up. If they keep it as their primary, then they can keep your property tax base. But the problem is, what if you have more than one child? Let's again use a scenario with 3 kids. Your current trust says that all 3 kids are going to inherit that property. You pass away, the 3 kids inherit the property, and then child A says, hey, I've got liquid assets, can I buy you guys out so that I can live in this thing? I'd really love it as my residence. They say, yeah, great. Problem is you now have what's called a child-to-child transfer. What that means is 2/3 of that property get a reassessment. Only 1/3 could keep what you paid. Well, that's not typically what people would have wanted. So instead, what we can do is put in what is called right of first refusal language, essentially giving those children the option to do that agreement prior to the distribution actually being made, which then allows it to be a full parent-to-child transfer. Everybody has to still walk away with the equal amount. So if child A can't give enough liquid asset to balance the scales, they're not able to do it. But if they can and they want to, now they can keep your full base. So it's important to come and again speak with us about, is this language right for you, and is this something you think your kids would want to take advantage of? The other thing is if you're planning to purchase a new property, so not one you already own, but are going to buy a new property, we can talk to you about, is an LLC worth doing? Because in some cases, if the LLC actually buys the new piece of property, when you pass, rather than a property transferring, the LLC is transferring, which can then extend, whether it's a primary or not, if the taxes have to be reassessed or not. So again, not for currently owned, but new purchases, we can speak about that as well. Medi-Cal. So, Medi-Cal has really wanted to keep us on our toes of late. If you heard us last year, you probably heard us talk about the fact that Medi-Cal was no longer going to look at people's assets for qualification purposes, but we're going to look at people's income. Why this was so important is had what is called a Medi-Cal Asset Protection Trust. What that trust purpose was is if you ended up needing advanced care that you were not sure you could afford without becoming completely destitute and selling everything off, we created a trust that allowed you to house your assets and protect them while still qualifying for this advanced care that many people unfortunately end up needing. Because if you've ever looked at long-term skilled nursing costs, and most people can't afford it, it's anywhere from $15,000 to $25,000 per month for a lot of different care needs. And a lot of people it's higher. Well, I don't know many people that have $15,000 to $25,000 in assets that are able to just go out to a care facility. So again, we saw a lot of people having to sell everything, basically in order to qualify for this needed care. Then Medi-Cal again said, okay, we're not going to look at what assets you have, we're going to look at what your monthly income is. Okay, great. So we created a Medi-Cal Income Protection Trust for the same purpose. That has been what's been in effect for the year of 2025. For 1 year. Medi-Cal has already said, just kidding. We're going back to assets. So, if you are concerned about qualifying for Medi-Cal, please note a couple things. One, they are going to look at your assets for qualification purposes. The level that they're going to look at is, do you have a primary residence and under $130,000? If you have under the $130,000, you could qualify on your own. If you have more than $130,000 on top of the primary residence, you cannot qualify without having to pay something. So that is where we can talk to you about is this Medi-Cal Asset Protection Trust, something that would help you preserve the assets you've built, especially if you still need to take care of a healthy spouse while being cared for yourself. If you have questions on this, please come and speak with us. Starting January 1 of 26, we are again going back to assets. This has led to a lot of confusion. If you're already on that account, you may get different letters that may be confusing. We're happy to help answer those questions for you. The Secure Act, so this deals with your retirement accounts. Now, it is really important with this one to note, we will not be your one-stop shop for what to do with the Secure Act. Anytime it has to do with retirement, we very strongly encourage you, if you have a financial advisor, to speak with them about it. And if you don't, you'll get to hear from Lifestyle Financial today and are entitled to a consultation with them. I would speak with them. Because the Secure Act changed how long you can contribute to an IRA, when you have to take RMDs, what that landscape looks like. But the other thing it changed is when someone inherits your IRA, how long do they have to withdraw the amount? Spouses, you can kind of ignore the bad side. Spouses, you still get to take it without extra problem. But for almost any other inheritor of an IRA or a 401k, you now only have 10 years to draw down the principal in the amount that you were left in that account. So this means two things. One, unfortunately, taxes have often gone up for those of us who are inheriting those accounts because you only have 10 years to draw down the amount. Apologize for my crying child. Her dad's got her. She's fine. So you only have 10 years to draw it down. The other thing, though, and why talking to an advisor now is so important, is now is the time you could possibly strategize to see how can I not be hit with a ton of taxes, but readdress and reassign where my assets are so that they're not hit with an extra special tax after I move on. Because when you only have 10 years to draw it down, the tax is higher every time that person has to take money out. My dad is a prime example. He was told his whole life, put it in retirement. So most of his assets are in his IRA and his 401k. I'm an only child, which means I'm not spreading out who's getting that amount. It's coming to me at that point. Which means, as much as my dad absolutely loves giving the government extra money, that is what would happen. I would have to take the assets over 10 years and pay a much higher tax than he ever would have expected. So he, working with my husband as his advisor, he has been working with him to readdress how he doesn't get hit with negative implications, but also, again, ensuring the government doesn't get their hand in the cookie jar more than they absolutely legally have to. Well, why does this apply to your estate planning? When I mentioned those lifetime protection trusts, one of the things that a lot of people want is their retirement proceeds to also get the protection for the lifetime protection trust, the protection from divorce and everything else. So a lot of people have named their trust as a secondary, or in some cases, primary beneficiary. But if you have outdated language addressing retirement accounts, what can unfortunately happen is it can cause a one-time tax on the full amount when you die, rather than them even getting 10 years. With proper updated language, they can still have that full 10-year extension. So it is imperative, if you want your retirement through the trust when you die, you're not sure if they will, you're not sure if you have this language, come in and speak with us. We can very, very quickly tell if you have this language or not, but if this is something of concern, it is so important we have this done right. Federal death taxes and federal gift taxes. So one of the things to note is with federal death taxes, most of us don't need to worry about them because the amount is about $14 million right now. What that means is if your estate is under $14 million, no death tax is paid. If you are in the more small category where you do have an estate though that is over that $14 million, please come and speak with us so that we can make sure you have the AB trust that we talked about, because that actually can double the exemption you are entitled to. If you are concerned about it and you're single, what things can we do in the advanced planning side of things? So if you are over that 14, come and see us. The other thing to note is if you like to gift. Some of us do. I'm definitely a gift giver. My husband, to his chagrin, he's very patient with it, but I love giving gifts. One of the things to note is that every year you have what is called an annual exclusion. What that means is this year, if you wanted to gift an individual up to $19,000, You could do so without ever telling the IRS. But what happens if you wanted to gift $20,000 to someone? You're planning to help them buy a new car. What would have to happen is you would need to tell the IRS you gifted that $1,000 in excess. You do need to file a gift tax return, but they would deduct it from your lifetime exemption pool, which is about $14 million. So the $1,000 will be deducted, but you should not have to pay tax unless you go over the $14 million in your lifetime. So this allows people to be significantly more generous without needing to worry about taxes affecting the generosity. So if you do have questions on that, if you're planning to give the larger amount, again, come and see us and we can help walk you through. Now with the federal estate tax, one of the things for married couples to note is when one of the spouses dies, you can do what is called portability election. Essentially what that means is you're going to look at what was the estate when the spouse passed away and how much of the exclusion was unused. You can then elect to add the unused portion to your exclusion for when you die. This is an extremely powerful tool because the exclusion amount and the exemption amount can change. And so while today it is extremely high, it has not always been that high. So if you passed away and it has plummeted to $1 million and you've got now an estate that's $3 million, if you elected to use your spouse's unused portion, your estate very likely would still never have to pay a tax, even if the exclusion plummeted. The reason this is important is tying it back to our trust administration department. When you lose a loved one, please come and speak with them when you are ready and able to. Because there are often deadlines for these exclusions and these exemptions and these benefits, but we can also help right the ship a little bit. Help you focus on what do you actually need to worry about? What are the things you don't need to think about? What are the things that we can take off of your shoulders? So that is where having an extra department, I'll call it, to help beyond the estate planning can be crucial when you're working with planners. All right, that is enough from me. I am going to step off and actually hand it over to Catherine Brown, who is our business and tax attorney. Oh, try not to break this. So what Catherine's going to focus on is more of the advanced planning things, some of which may not be applicable, but if it is, absolutely know that she is a wonderful person to get to work with, and I hope you do get the opportunity. Here's Catherine.
Thank you so much. And we're going to do just a quick technical swap, but I'll go ahead and sort of introduce myself and introduce what we're going to talk about. I'll really just be up here for a couple moments. As Victoria mentioned, I'm primarily a business attorney. I work in our business, tax, and estate planning department, or advanced planning department, which we're going to talk about a little bit more after the break. What I want you to take away from this is just broadly, since we're in the section of legal changes, what has changed mostly in the realm of business law or laws that will be applicable to businesses. But because this is more of a niche subject for our audience today, I'd like to get a poll of how many business owners do we have in the room, consultants, maybe you run your own business or you're currently running a business. Hands up, okay. Anyone with rental properties, tenants that you currently rent a second, hand up I see. Any other hands? Okay, so I'm gonna go over these very quickly, just because we are doing a live stream and I want people to know what Copenbarger can help them with, but I won't go into detail. So I really will be up here in just a moment, and I'm waiting for David. So just give me a second.
So yeah, that's
So one thing, and I might be able to do this without slides too, since we're going to go really high level. One thing I want everyone to take away here, and you're probably already familiar with this, in California, laws change constantly. Tenant laws update every single year. So for anyone who is a landlord, or anyone who is currently renting perhaps. Laws have updated for both residential and commercial tenancies. Some of the topics that we have in the content today is regarding security deposits for residential tenancies. There's some limitations on that. Also notice windows and notice to vacate has been updated. If any of this realm of law applies to you, if tenant law applies to you because you're either a landlord or a current tenant, please take a look at the slides and ask us questions if you have any questions after the fact. Also, if you are a landlord and dealing with a troublesome tenant, or if you know someone who is a landlord and dealing with a troublesome tenant, and you have potentially an eviction case on your hand, please note that Elaine Alston, our attorney in our litigation department, can actually help you with that type of dilemma, we'll say. So tenant law updates every year. Look at the slides to see if it applies to you. Another thing, employment law updates every year. Most of us in this audience, that does not apply to. If anyone's on the live stream that it does, there's a list in the slides about some of the laws that have been updated in the employment law realm. We can help counsel you on any of that, whether you're the employer or the employee. And again, a little plug for our litigation department. If you're an employer dealing with an employee problem, please come to Elaine. She may be able to help you from a litigation perspective. We may be able to step in. We're almost there. What? I think he's making a quick change. Okay. The other, let's see. So tenant law, employment law. This was the next topic, real briefly. We had this, if you were here at our last seminar, I see a lot of familiar faces. So some of you have it, some of you were. But the FDIC trust rules have changed. They have actually been simplified for irrevocable trusts. So Victoria, most of her presentation was about your revocable trust, but if you're in the realm of also irrevocable trusts, or in the case of a living revocable trust, once you pass away, it becomes irrevocable. So for irrevocable trusts, the coverage for insurance is the calculation for it is simplified. It's $250,000 for any, and it's the same calculation for revocable and irrevocable trusts. So it's just mirrored if you were familiar with it. You have a coverage of $250,000 per beneficiary, per trustee. So if you're looking at your spousal trust, that number is doubled. But you have a cap of 5 beneficiaries. So depending on how you've allocated, and this is a great question even for Zach, who will come up next, to look at what your coverage is, or even Victoria, when you're doing a review of your trust, how is your distribution allocated, and is there any risk for your insurance coverage? And that's all I'm actually going to cover in this segment. I'll see you a little bit after the break, but now I'm going to pass it over to Zachary Raymond with Lifestyle Financial, and he's going to give you a lot of helpful tips how to grow your portfolio. Come on up. Thank you.
Thank you, Catherine. Good morning, everyone. I am Zachary Raymond. You may have met my other half. Or I guess my other 2/3, because we have little baby Emma with us today. She runs the house. That's a statement and a joke. So, good morning. My name is Zachary Raymond. I just said that. As a representative of Lifestyle Financial, let me give you a little background about who we are. I know some of you, I see some familiar faces. If not, I just made new friends. This is awesome. So, Lifestyle Financial has been around since 1995. We were founded by Laura Copenbarger, who was married to Lloyd Copenbarger. They still are married. Laura has since retired. Her grandson, Charles Sosa, who some of you may know. There's a few differences between Charles Sosa and I. I'll let you, if you know him, point them out. If not, I have the hair. So, our role here, why we very much are appreciative of the Copenbarger Estate Planning Law Firm and a family that help families, is that is our mission. Finance, show of hands. How many people here have more than $5? Live streaming, you can raise your hands, I can't see it, but everybody raised their hand, almost everybody except for the people writing notes down. That means that you are of concern to us. In financial planning, it is not the size, it is so much as the plan and the situation. No two situations are the same, nor is there ever going to be an identical plan. And it overlaps more so now today, and we'll talk about this in a little bit, the relationship between estate planning. You just heard from two amazing speakers. We all met at law school. I am not the attorney, so please do not ask me a legal question. There's probably a joke about that, I just don't want to be caught on camera about it. So what we try to do is take the financial planning rules that are changing, and there are a lot of changes that I'll talk about, put them into the four walls of all these legal documents. You just spend a lot of time working with brilliant attorneys, establishing and making sure the plan is set. And you'll see some numbers up here, but it is not just for your lifetime, or it might be if you have a LLC or an irrevocable trust, it's for the lifetime of the entity that you're trying to fund. That was about the most complex statement I would say, because finance is not supposed to be complex. Everybody should be able to understand it, and that is our job. We try to establish guardrails or certain plans or contingencies of plans or explain situations that might take into effect for everybody's financial plan and situation. You'll go through all the wide variety of estate plans that are there. Maybe there are children who have special needs, so you might complement that trust. You spend so much time setting up and funding, then you want to have an advisory team to give you that advice and guidance. Yes, there's a lot of repetition of finance. I say finance a lot, I say advice, and I say guidance because all those are the main points that should stick in your head when you're thinking about these sort of plans. Because it's not just a set it and forget it. There is some value to that. There's a piece that's valuable there. But it just shouldn't be dropped in a bucket, thrown into the ocean, and just sink 30,000 leagues under the sea until somebody writes a story about it and goes, hopefully you strike it rich. What you want to understand is that we are going to first and foremost focus on you. You have to focus in the present. I was talking to some people earlier today, so I usually tell the idea if you want to take care of others, or you have a charitable arm, or there's something you're planning for, that is wonderful. A big part of the financial and estate planning and working hand in hand is making sure that you are first able to demonstrate that you can take care of yourself. Financial due diligence. I usually give homework to clients, not like a 5th grade math teacher, even though I could pass for one probably. It's more because when you feel that you're working hand in hand with your trusted financial professional, you understand these are the rules that we set in place, and they're going to go a long way to achieving your goals. Everybody here probably has some sort of financial goal that they would like to have. Or if you already have it, you probably want to maintain it. But what you want to do is make sure that you're constantly revisiting this plan. It doesn't mean to stare at it every day. I'll stare at your plan every day. That's part of my job, except for Saturdays and Sundays. But for the most part, we are going to have a long-standing relationship. We grow over time, and then we refine the plan as certain situations come up. Show of hands, how many people are parents here? How many people are grandparents here? How many people maybe want to be parents or grandparents, or want to set something aside for someone who is maybe a generation down the road, or an organization down the road, or a charity down the road? Eventually I'll throw out every investment in a portfolio, whether it be real property or real estate, or something that's a tangible asset, we like to say, or an intangible asset, has a role to play in the financial plan. And you really want a financial advisory team to put it all together. No, I am not a realtor or a mortgage broker, so I am not going to buy or sell your house. But understanding the overall value of the asset, there are two real components. There's what you own and what you don't own, or the equity part of the house and the liability part of the house, or the mortgage, or the loan, or you have a HELOC, or some sort of note maybe. All of these are financial terms that then we will take back as part of your overall financial plan. And then there's the other side of this. Victoria mentioned, show of hands, how many people have any form of retirement account? Such as an IRA, a SEP IRA, a 401k, a 403b. There's various letters and numbers that I can also throw out, so they all apply. Those are another basket, either something that might be tax deferred or an after-tax retirement account. Again, I could probably pass for looking like a CPA, but we have to stay up to date on these tax rules because it directly impacts your financial plan. So for all those who have advisors elsewhere, I came from a small firm called Merrill Lynch. If you know me, I usually make jokes about it. I'll talk to you at the break about it. I have a lot of stories. They taught me a lot. I take all of that and I bring it to Lifestyle Financial. What you want to have is you want to have that team that stays up to date on top of everything and does not hide behind the fact that they're not lawyers or accountants, that's not an excuse for your money not be tax aware or legally aware of all the various parts that impact money. We had a phrase on the previous slide called the mosaic. My mother's an artist, so I usually try to use art in a story. I am not an artist, so this is how I try to give her some respect. When you have a picture and you stare 2 inches away from it, you're not going to catch the whole picture. You'll see a couple of frames, you'll see the imperfections, and you won't capture the whole image. Take a few steps back, maybe something comes into frame, you can better see it, you can maybe see the finer tree, or if it's an art piece, I'm just going to see a golf course outside, so there's trees, so there's a flow on that. And then take a few more steps back so you see the entire picture of the mosaic. You see everything working together. The foreground, the middle ground, the background. That is how financial planning needs to be put into focus. Especially in what is happening today. And I do like to keep this interactive. Show of hands. How many people are still hearing the words, let's see, inflation? Federal deficits? National debt? Leverage? Has anybody heard of AI lately? It's a good one. Yeah. So these terms are all now financial terms, and they have been for a very long time, and there's variations or different ways of using these. But they all impact directly your financial plan, whether or not you want to, and it's fine, but somebody has to be giving you facts. As friendly as I might seem, and I really am a friendly person, I'm not supposed to be your best friend. I'm supposed to be your advisor. So I'm not going to say something that you might always agree with, or I'm going to challenge the idea you have to try to make sure I understand it to give you the best path to get to that financial goal. And then make sure that it relates back to your estate plan, make sure that it corresponds and relates back to what your tax advisor maybe offered you, or there's a gap, and they'll say, you should go to Copenbarger and make sure this is in your estate plan, or ask your accountant about this. We recently had an educational talk sorry, I thought that was a question. We recently had an educational talk about how people might want to make strategic gifts at the end of the year, either to funding education for a grandchild or maybe gifting something out of your estate that's allowable. There's different mechanisms to do that, and there's various tax impacts to do that, or even how you want to gift. I mentioned if anybody has more than $5, generally thinking, because I remember my first job was $5 an hour, and that's usually why I picked that number. I was a busboy. It very much highlights how do you want to move money, or if you have a various size of an estate, how you want to access this equity, this ownership, to best transition into a plan or to a person or to a charity. It's time to figure out what you want to do. Sometimes plans, you have a well-set plan. I really planned X, and then something else happened, so then I have to find a new path to get here. So maybe it's now X plus Y. For those of you who don't know, that's algebra, and we do not cover algebra in Lifestyle Financial. In this changing landscape, a very important rule of thumb is the world in the investment universe is getting smaller and smaller and smaller. What happens in Europe will directly impact out here in Cupertino, because that's where Apple is, and Apple has to go through 12 rounds with the European Union to make sure they don't pay too much for all of their intellectual property in France. That was a lot of words, but basically what I'm trying to get the point across is you need to have someone who's up to date on what's happening all around the world, because it does come home. We see it here because we're, depending on the chapter on the 17, X amount of distance related to $10 trillion, because there's a lot of tech companies out here, and also a lot of financial companies out here. So a lot of news, a lot of information, a lot of details actually come right through our own backyard in Silicon Valley. It's a great resource that our firm prides ourselves in staying relatively on top of. And a good part of that is because we work as a team. There's not just one advisor, there's multiple of us, and the research that we bring to the table every day, and we try to share it with you all. I mentioned that there were updates. So this year brought something called, and forgive me, I call it ABBA, but it's the One Big Beautiful Bill Act. Show of hands, anybody hear of this thing? Yeah. So it covered a lot. And there's still stuff that is yet to be determined. As I said, I'm not a lawyer, but there are direct financial outcomes from that legislation that you want to talk to your estate planning attorney, you want to talk to your tax person, or if you use TurboTax, you'll be finding that there are less and less free options at TurboTax that keep on trying to charge you more, because the idea of taxes is getting more and more complex. So take all of that information and then come back to your financial advisory team, because you want legal, tax, and financial to all work together for your situation. So we're talking about things in the present, but a lot of what we talk about in the present is to set up for the future. You can only really think about the next 40 years if you're able to take 5 steps out to your car and hopefully drive back home. They all relate in this one single point in time to build a lifetime of financial wellness. So we try to take phrases such as holistic financial planning, behavioral finance, legacy planning, and wrap it into one financial plan that's easy to understand. This is where I came to some hard numbers. We challenge you for the 40-year plan. Despite how old I may look, I will probably still be working in 40 years, so you'll probably be stuck with this monotone voice and this look for the next 40 years if you want to talk to me. But if nothing else, it's a good gut check to make sure your plan is going for 40 years, even if you won't be here for 40 years. Again, that's the part where I'm not your friend, but I'm telling you the facts because you owe it to yourself to have those informational points in front of you all the time. So, again, this is supposed to be interactive. Financial planning revolves around people asking questions and getting answers. I'm a big believer in it. Come by our booth, set up a free consultation as an attendee of this seminar. We'll talk to you, and I will talk a lot. In case you haven't figured that out, I do talk a lot. I look forward to seeing all of you. Thank you so much for this time. I will give it back to someone at Copenbarger to discuss the next update. Mr. Chris Carroll, the CEO of Copenbarger. So everybody be on your best behavior.
Thank you, Zach. Good morning.
Good morning.
Oh, that was the loudest I've heard this room all morning. Yeah. Good morning.
Good morning.
Well done. Wonderful. All right. Thank you all for joining us today. Show of hands. How many of you are clients? Raise them high. Raise them high. Come on, you guys can raise them higher than that. There we go. Thank you. How many of you are Access members? Okay. How come there were more hands raised for Access members than clients? If you're a client, if you're an Access member, you're also a client. All right, let's try it. Access members, raise your hand. Clients, raise your hand. There we go. Okay, that's better. Perfect. Thank you. I have the numbers right here. I just like to see it. So. All right. So what I want to talk about today is the Access membership program. This is mostly for existing Access members. Now, that doesn't mean if you're not an existing Access member, you just completely completely stop listening. We'll have a break in like 15 minutes, 10 minutes, I'll try to do it quick. And you can move to a break right after, and so you can go to the bathroom then, get some nachos and cookies in the back, all that good stuff, all right? So, for existing Access members, we've had the program for almost 25 years. We created the program a long time ago. Copenbarger actually created the program, and we have over 2,500 Access members up to this point. And we've actually kept it at that cap from the very beginning. So once we got up to 2,500, the only way people were allowed to join the Access membership program was if other members had passed away and spaces opened up. But since we created the program, we've actually grown in size and in scope as a firm, and so we are people that can join the program. And so I want to talk to you about how we're relaunching the Access membership and what's changed for you as members and what's available for other people. All right. First, I want to go into why the program was created in the first place. Lloyd created the program because not everybody has attorneys in their family like Lloyd. Not everybody has son-in-laws and sons and grandchildren and all that, brothers that are all attorneys. And so when you need somebody to call, when you need an attorney, you wanted people to have access. And that's why you named it the Access program. This was long before I was at the firm, but I like the name, and we've definitely kept it. And we're looking forward to relaunching this and telling you guys what's changed. So, existing Access members, good news for all of you. Everything is going to be better for you, and you don't have to pay anything else ever. All right? So, if you keep your existing Access membership, you want to stay with your existing Access membership, nothing changes, there's no monthly fees, there's no increase in cost, nothing but your benefits are actually increasing. All right? So we have a giant chart over there. All right? And then we also have some little charts that you can take with you that will explain to you what's changed for the Access program for you as an existing member. But one of the things that you'll notice is up to this point, you've gotten a $300 annual credit that has actually been increased at no cost to you, no change to you, to $400 a year. You are still going to get your free estate planning consultation every single year in review. You're still able to share your benefits with as many new people as you want without affecting your own. So if you're an Access member, you've got 3 kids and 4 grandkids, and you want each of them to have the 2 hours of consultation time with an estate planning attorney and the $400 credit each. They each get it, all 7 of them, 3 kids, 4 grandkids, 7 people, right? They can all get it, and it doesn't affect yours. You can still come in and get the same thing. All right, so the benefits are going up. We're also adding some additional resources for you to look over every single year, a checklist, for you to be able to make sure that you're staying on track. And when you need to come in, when you need to ask certain questions. We're adding in free financial planning consultations. We're adding in exclusive webinars and events just for Access members that other clients will not be invited to. All right, so there's a lot of different benefits. I'm not going to spend this entire time talking about every single one of them because it would take a long time. That's why we printed out such a big sheet over there. All right, but the good news is for existing Access members, all of your benefits are increasing. They're all getting better. You can pass it down to your children and grandchildren in your lifetime. You can transfer it on your passing. A lot of good stuff in there. So if you have questions about it, you can come and talk to me. I'll be at the table over there with my tablecloth at the break. All right. If there's also opportunities, if you choose, and again, this is your choice, if you want to change it to a different tier. So what we're changing for people who have not joined, right, what we're adding on this relaunch is 2 additional tiers that you can join. So if you're somebody who has a lot of children or a lot of grandchildren or a lot of great-grandchildren, and you really care about passing on legacies, making sure all their estate planning is covered, then there's tiers that you can join where the benefits increase. Also, if you have a business, or if you have entities, or extra real estate, if you have different taxes that you want done, there's going to be more service areas included at the other tiers. So when we first started the program, we were an estate planning law firm by and large. That's what we did. We did wills, we did trusts. Over the years, we've started to transition. Now we do estate administration, we do probate, we do conservatorship, we do guardianship. Then we expanded even more. We do business, we do tax, entity formation, real estate contracts, prenuptial agreements. Then we expanded even more. Estate litigation, small litigation, contract litigation. All right. Now, the Access program did not grow with those services. It was always estate planning based. But as the firm has grown, like I said earlier, in size and scope, we wanted the new program to be able to give you access to all of those different service areas. So if you're somebody, this is not for everybody, I want to be very clear about that. We have no expectations that everybody's going to be changing into different tiers or anything like that. But if you do think you're one of those people, you like to change your mind a lot, or you got businesses or a ton of great grandkids, something like that, you should look at the other tier options. You would only have to pay the difference between what we're charging on the base tier and the upgraded tier amount, and then the monthly fee that comes with that. But again, you want to stay in the existing tier no matter what you're getting. All right. So the 3 tiers, there's the Foundation, Heritage, and Legacy tier. All existing Access members will move into the Foundation tier. Again, I don't want to hear any upset people. All your benefits are increasing, so you're winning no matter what, and you don't have to pay anything else. Okay, so that was for the existing members. If you're not a member of Access and you're curious about it, you have questions, you want to see if it's a good fit, I'm not just going to tell you yes, it's a good fit because we want your money, even though we're lawyers, right? I will make sure that we make sure it's a good fit for you. You would be happy. That's how we keep long-term clients and multi-generation clients. We can have that discussion and figure out if either the Foundation or the other 2 tiers are good for you. Again, it's typically better for people who have larger families, right? Especially if most of the children and grandchildren are in the state of California. If you have real estate, business, you think you change your mind a lot, you want to update your trust every year and change who upsets you and who you want to cross off and who you want to add, better for those people, all right? Perfect. Okay, so again, going back to the original cap. Originally, we capped the program at 2,500 members. That's because we had Lloyd, Larry, and James. Those were the 3 attorneys we have. Now we also have Victoria and Catherine and Elaine and Matt and Greg and Mark. We actually have 2 Marks. Megan. So we have a lot more attorneys that can increase our capacity. So we are very comfortable doubling the size. So we have 2,500 open spots. To put it in perspective for you, we have just over 40,000 clients, so I do not anticipate those spots to stay open for that long, but probably a good 6 to 18 months the program will be open, and then we'll open it up as people pass away over the coming years. All right, perfect. So if you have questions about Access, again, I'll be at the table over with the white tablecloth. Happy to answer questions as I can. We have some handouts, some brochures and stuff that you can take back. And then if you have questions, you can either email access@copenbarger.com. You can call and ask to talk to one of the Access coordinators, and we will go from there. I believe it is time for break. If you want to make an appointment, the table's over there to the back right. Make sure you fill out your green evaluation forms. And now I'm stalling because Victoria's walking up here. Don't trip on the cord. Thank you very much.
Trying to do math in my head. Okay, good. It just changed to an even number. So we'll see you guys back here at 10:40. So that'll give you time where you checked in. There again are appointments available. If you're curious about the new Access program benefits, either as an existing member or a hopefully new member, again, he'll be here. Lifestyle will also be to your left and my right. If you didn't already find the restrooms, they're out those doors to the left, both for men and women. There are nachos now in the back, as well as some cookies, so if you'd like some more nibbles, please go for it, and we'll see you guys back here in a moment. I hear excitement over cookies. They're good.
Question or for us? We're going to be, I think, okay.
All right, brother. Even though we both it needs to be.
That's why I polished it ahead of time, just so you get some more like, you know.
All right, we're gonna get started in just a minute, so please get your, we do have some time after the entire presentation today. We'll stick around to answer any questions. So please head to your seats and we'll get started again in just a moment. All right, I'm going to go ahead and get started with the next segment of the presentation. I'm going to speak to you guys for just a short period of time here, again about some topics that are not always applicable to everyone, but we want to make sure that you know, and that in case you know anyone who they may apply to, that you know that Copenbarger can provide these services for you and can help you with some of this, what I like to call alternative planning and also advanced planning to your estate, to your businesses, to any endeavor that you have that you're working on. We can do a lot of different, help you with a lot of different areas of legal services. So when I'm talking about alternative planning and advanced planning, we're looking at a mixture of topics here that could deal with your assets, your estate, how you're managing them. Are you protecting them sufficiently? But also your business assets, any endeavors, anything you've invested in from a business perspective too. How can you protect those interests and those investments and make sure that your legacy is secure in that way? The first section of our presentation before the break was the first section was really about getting that baseline and that foundation, that revocable living trust that protects your estate from probate. But then what about all those other liabilities that you could encounter? Tax liabilities, any number of liabilities with a business. How do you protect against some of those other areas, depending on what your portfolio looks like or what your livelihood looks like? So as a business attorney, I work mostly in businesses, LLCs, corporations. I help people's partnerships, family limited partnerships, general partnerships. I help people set those up, maintain them. Now, businesses aren't just an operational business. They're not just maybe a consulting service that you're running on the side, or maybe some service that you're providing or goods that you're providing out in commerce. They could also be asset holding vehicles. We could, or they could be if rental property operations, management, protection vehicles. The great thing about LLCs, specifically limited liability companies and corporations, are that they offer a legal protection that's unique to any other type of business and type of trust, and it's a personal liability shield that is called or referred to as the corporate veil. So when you set up an LLC or a corporation, you actually create a shield. Your assets on one side, the business assets on the other side. Anything that happens in the business, as long as you're running and maintaining the business as a separate legal entity, your assets that are outside your net, anything else that you have is protected from those business liabilities. This is why we frequently and very strongly encourage anyone who's running a rental property to set up an LLC to hold and maintain that rental property. Because rental properties carry inevitable liabilities. Could be any number of things. And this goes above and beyond having general liability insurance as a rental property owner. So if you or someone you know has a rental property or is thinking of purchasing a second and renting it out, please come see us and see what it looks like to get this additional liability protection in place. So that's one big alternative planning solution that we work with clients very, very frequently to set up. If you have a separate business venture, if you are, again, doing consulting services, if there is some other business that you're running, business venture, we can help you with a lot of the compliance needs that business has. There's licenses, local licenses, any number of registrations. You could have branding associated with that business. We do offer trademark, copyright. Those are all legal services that we can actually do in-house at Copenbarger. And then, of course, if you, as I was mentioning before the break, if you have employees or if you gain employees as a part of that business venture, we can also help with your employee compliance and make sure that you have handbooks in place. The other side to this segment is our advanced planning for estate planning. This is more about, and this is something that we do in our department. We have a wonderful attorney, Kevin Vandenbroek, and he has joined us fairly recently, and he works heavily in this area in advanced planning. So this is setting up and establishing irrevocable trusts or other types of vehicles and strategic planning about your overall estate to help. There could be a number of reasons, whether you're trying to minimize that impact, if you're looking at reducing the hit of your estate tax when you pass. There are a lot of different types of vehicles, some of them listed here, that we can create to try and shift some of your assets to away from you, right? Away from and into an irrevocable trust to help minimize that estate tax hit. And then there's also some vehicles that have specific objectives. So if you have a charitable intent, or if you want to make sure that your grandchildren, your children, your grandchildren see some of the benefits of your estate, are direct beneficiaries of some of these vehicles, or if you want it to be a charitable investment, if you'd like to, if you have some charity, there's tons of different types of vehicles. This is typically for if we're looking at, for the most part, individuals who are impacted by that estate tax. So we're looking at you're at or close to, maybe you're approaching that estate tax exemption, and you want to help create a strategic plan that helps minimize that impact. Those are all what I consider advanced estate planning. And that's something that we can help with, but it's very unique to each individual and what your current portfolio is and what your assets are and how they appreciate. So it will not apply to everyone. Now at this point, I'm wrapping up. If you have any questions, please feel free to reach out. But I'm going to pass it over to James Kosarev, who's going to talk to you more about the administration side, also get into some litigation, all the fun stuff, and take it away. Thank you very much.
All right, thank you. Clap, 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 clap. Well, they said don't hold the bottom on this. All right, so some of you know who I am. I'm James Koster. I'm one of the attorneys at the law firm. And what we're going to talk about next is all about administrating some estates. And what I mean by that is administration is really just a process, right? It's when the trust matures. That's a nice way of saying when somebody passes away or they become incapacitated, right? Well, when it matures and it's needed, then things have to happen. And so really it's just a matter of dealing with the different processes and procedures that lead to or get to where you want to go. Because when you arrange a trust, right, we're an estate firm. I think initially it was an estate planning firm, but now it's an estate firm where we're kind of in-house with everything, right? We kind of go full circle with everything, and so we help people, right? When the families, like this, and these are your kids, right? And if you'll notice, they're fighting over a crown and some coins, right? So that's what we end up having to do or help to do. And it's getting through the process. And like somebody referred to earlier today, they're not fighting over a bank account, right? If I've got $90,000 in a bank account and it goes three ways, how much does everybody get? A third. But if it's that colander they're talking about, how do you split that up? Right? You go into court and you get a judge to order that, you get visitation of the colander during Christmas and you get it during Thanksgiving, and right? And Easter goes to the other one. That's kind of ridiculous, but that stuff kind of happens. And so it's a matter of what has to happen. And there's laws, right? I look at it that administration is cut up into four categories, or four disciplines. It's the things it's what the law requires a trustee to do, right? The legal things, it's tax related. What are the tax issues that have to be addressed? How do assets transfers, the third. And the fourth, I think, is kind of intuitive. It's just kind of helping to wrap up the person's estate, whether they're deceased or incapacitated. You think about it from a simplistic standpoint, and I'll address that last one first, is if you think about it simply, my dad passed away recently, but he lived in Arroyo Grande, and I lived in Huntington Beach. And so what do I do with the mail? Right? How do I go up there every day to collect the mail? Well, I don't. So intuitively, we know, wait, I'm going to have that mail directed. Right? So if he had a car, and there was insurance on the car, well, I don't need the insurance, at least not all of that insurance anymore. So I contact the insurance company. And those things I think are intuitive, and we as individuals know that we should do that. But there are things, the other three things, they aren't so intuitive. What does the law require? Well, if there's real estate, and we think about this, if Stephen here and I own a piece of real estate together, right? We went into partnerships on a piece of real estate, and we don't have a trust, we don't have a will, we're separate families. I mean, we're not even related. Well, unless you count Noah as our forefather, then maybe we are, right? But suffice it to say, if I pass away, his name's on the deed and so is mine. Well, how do we address that, right? So something has to happen with real estate. There's a legal process. It's not like I said, it's not in a trust. It may or may not have to go through probate, but there's a procedure, right? And somebody has to, deal with that procedure. And whether it's Stephen or whether it's my family, there's a process and a procedure. So even though somebody may not have a trust, because they own assets, in the manner in which they own assets, something may have to happen. And so if you were with us a couple of years ago, we went over what are the legal things to do, right? And I'll go over a few of them, but I'm not going to spend too much time today going over these, because I'm going to settle today on how do assets transfer. That's the main focus of my conversation today, is going to be how do assets transfer when somebody becomes incapacitated or passes away. And so there are things that have to happen, right? Notices have to go out to beneficiaries and government entities. The will has to be lodged. That have to get a tax ID number. These are the things that have to happen. Trustees, if somebody's a trustee or an executor under a probate or an agent, right, a power of attorney agent, whether it's financial or medical, there are certain duties you have, right? Why? Because you're in charge of somebody, person, or you're in charge of their assets. And so there are certain rules, right, certain laws that you have to follow and comply with in order to do your job correctly. And this is not a total list of, this is just a part of the rule that you have to follow. And if you're going to summarize it, and if you look at all of them, it's basically do unto others as you would want them to do unto you, unless you were, crazy. Right? And so from that standpoint, right, it's just, you're looking, it's a selfless type of a situation, not a selfish type of a situation here, when you're acting as a fiduciary like that. There's a couple of them in here that I always like to bring out. One of them is partially. Impartially means, generally speaking, we're talking about a situation where a family member or a friend has become incapacitated or passed away, and it's like, if there are rules within that controlling instrument, whether it's a trust or something else, and let's just say a trust for simplicity. If there's something in that, the person, like if my dad became incapacitated, I would have to do exactly what the trust says to do as it relates to who it provides for. Right? I have 5 siblings, right? So my dad is incapacitated, and one of my siblings said, well, let me have some of my dad's money. I'd have to look at the trust, and if it just says that trust is only to provide for my dad, can I give anything to my siblings? No, right? And if I do give things to my siblings, what am I doing? I'm violating the trust, I'm violating the law. Right? And so from that perspective, we have to look at it from a standpoint, and dealing impartially with beneficiaries is if there's multiple beneficiaries then involved in this, right? If dad passed away and now it's the 6 kids, can I show favoritism to anybody? No, because that's being partial, right? So if somebody's living in my dad's house, and I say, as trustee, continue to live there for the next couple of years. No one's going to care. And I'm the trustee, I'm in control. Right? Can I do that? It depends. Right? What does the trust say? If the trust doesn't allow me to give you, or give me the permission to allow you to stay there, I got to say, no, get out. You have 60 days to get out of the house, or a reasonable amount of time, whatever that case may be. Right? So I have to comply with the rules, and I have to comply with the trust. So I can't deal impartially. I cannot show favoritism. Co-trustees, I hate them. You guys know that, right? I don't like co-trustees. You don't? Some of you do. But for those of you who don't, I don't. Why? Because co-trustees is a committee. How efficient are committees? Right? So mom and dad says I'm going to have, I'm going to, like, let's put it this way. My parents had 6 kids. What happens if they said, okay, all 6 of you are trustees after we pass away? My dad died in January. I'm about ready to wrap up that administration. Right? If there were the 6 of us involved, we'd be nowhere close. Nowhere close. And so, and I'm not the oldest child. Any oldest children in here? But you're an only child, right? You don't count. You have your own separate problems. so, all right. But oldest children tend to want control.
Easy.
No, but they do. And the reason they do is because that's how they've been programmed by mom and dad. And I'll use my older sister as an example. As my parents got old, right, as we started to grow up and my parents, started to go out after the kids were younger, who would they say, which child would they say, okay, you're in charge, you take care of everybody? The oldest child. right? It's generally the oldest child. And so the oldest child has been programmed to be in control, right? Because the parents have done that, right? But they may not make the best trustee, right? Because because of that control issue. It's because it's my way. I'm in charge. They put me in charge because I've been programmed to do that all the time. And so when you have co-trustees and you've got one of them that's an oldest child like that, they're going to still want to be in charge. And it can slow other kids, right, are tired of you being in charge. Right? And you've always been in charge. And so co-trustees isn't necessarily a good thing. Diversify accounts. So if I'm a trustee and you're all the beneficiaries of the trust, right? And let's say you're the beneficiaries of my dad's trust. Oh, every single one of you. You get a piece of the estate. He passed away in January. I'm getting ready to make distributions. Thus far, you know nothing about my dad's estate, right? You don't. I've not given you an inventory showing you what the assets were when he passed away, and I've paid all kinds of bills and everything else. But now I'm ready to make a distribution. I'm going to hand you a check. Are you going to be satisfied with just what the check says? No. Oh, I'm trustworthy, aren't I? You don't trust me? No. Okay. But the point is, right? Because it's a matter of trust, and it's a show me thing, right? Everybody's from Missouri when they're a beneficiary, right? So from that perspective, it's like, okay, I have an obligation then as trustee. It's not your duty; it's my obligation as a trustee to tell you what I've collected and what I've done with the assets, right? So there's a duty to an account. I have to account to the beneficiaries what assets have come into the estate, how those assets have been spent, dealt with, sold, whatever the case may be, and ultimately how they're going to be distributed. Why? So you can make an informed decision on whether I've treated the estate fairly or whether I've taken something from it or unfairly treated the estate of the trust. So duty to accounts are very... Trustees have discretionary powers as well, right? So discretion, it's my decision on what to do. And those have to be exercised reasonably. So can I ever say as a trustee, because I said so? No, I can't. Right? Now Stephen here is laughing because he's heard that a lot. His mom's probably said because I said, or dad has probably said because I've said so. Right? But none of the others of you have, right? I know you have. You've never said that to your child. You've never heard your parents say that to you. But that is sole and absolute discretion, right? When somebody has the ability to just say, because I said so. Trustees can never do that. They don't have that discretion. They have reasonable discretion within the law and especially the trust. And by the way, the trust supersedes the law, so long as it's not illegal or against public policy. So trustees' duties. Notify, here's some more of an expansion of some of that law. Tax returns. Just because somebody passes away doesn't mean you stop filing tax returns. And even if the decedent, like my dad, let's assume he never filed a tax return for the last 10 years because he didn't have enough income. Well, as a trustee, I'm still going to file the last year's ones. Why? Statute of limitations, right? Well, what most people forget about filing tax returns, even if they don't have income, is statute of limitations don't begin to run against the government unless you file the return. So what does that mean? That means if you made a mistake and you were supposed to file a return and pay taxes, right? The IRS can come after you, your estate, your family, whatever, 20, 30, 40 years from now. Because you never filed a return to start the statute of limitations preventing the IRS from coming after somebody. Okay? So the preparation and filing returns is very important in my opinion. Because as lawyers, we either want to keep statutes open to allow lawsuits or close them to prevent them. And in this instance, it's closing it to prevent a lawsuit against you or your family or your your estate or your trust. They talked about estate tax returns, portability election, basis. I'll stop on basis, just as a little reminder. Remember, basis, and for CPAs, this is like, the nails on the chalkboard. The basis is essentially what I paid for something, right? So if I paid $100 for something, and then later I sell it for $300, then the capital gains tax is determined by subtracting what I sold it for, or what I paid for it from what I sold it for, right? So there's a $200 increase there, and I have to pay tax on that $200 increase, right? That's basis, and that's part of the capital gains issue. Well, if I sell something and there's tax on it while I'm living, the thing with basis is when I die, if I buy it for $100 and it's worth $300 and I die and the family sells it for $300, tax. So identifying and valuing all of those assets as of somebody's date of death is very, very important for a tax perspective, right? So whether it's gold, silver, Bitcoin, real estate, stocks, mutual funds, whatever, anything that tends to go, businesses, anything that tends to go up and down in value, they all need to be valued as a date of death in order to capture basis. The other thing about basis too, and this is for surviving spouses as well as family, if there's like rental income in there, that new basis can be used for depreciation again. You get a reset depreciation schedule when somebody passes away. Even though that property may have been fully depreciated during your and your spouse's lifetime, potentially when one spouse passes away, that entire property could get a new basis. So that type of information is very important. Property tax, for the most part, there's no exclusions anymore. That's the way I like to say it. There's a very narrow one that with my primary residence, if a child moves into that, gets that house as an inheritance, and they use it as their primary residence, and so long as they're using it as a primary residence, it doesn't get reassessed. But if they move out and stop using it as a primary residence, it gets reassessed. So it's only as it's used as a primary residence. And thanks to the voters of California for giving us that. Sole ownership. Okay, this is kind of where I want to spend some time. And look, I'm out of time. No, I'm only kidding. So this is what we're talking about, and there's different levels of ownership, right? We've got some sole ownership is me owning it in my name, by myself, right? Then there's joint ownership, me and my wife and kids, right? But how do we own it? Do we own it with right of survivorship? So if when one of us passes away, it automatically goes to the survivors? Or is it tenants in common, where if I pass away, my portion goes through my will, my trust, or whatever the case may be, right? And so how do we own it? And so is it joint or is it tenants in common? Community versus separate property for spouses. That makes a difference, right? Or community versus joint makes a difference for tax reasons, right? So how do you own ownership? How do you own the property? Payable on death or transfer on death, that's like a beneficiary designated. Same thing with IRAs, 401ks, life insurance, annuities. Those will have beneficiary designations to them, or can have. Do you own it in a trust or not in a trust? Is it owned by a business? Is a business owned, right? Because think about it. Anybody here own any stocks? Yeah, a few of you do, right? Okay, so does that mean, do you or do you not own the company when you own the stocks?
Importantly important.
Yeah, you own it, right? You own a part of it, right? So from that standpoint, it's like, okay, so there's an ownership interest in that, in the whole company, right? You're a shareholder, so you literally own a part of the company. So how you own it, right? Whether it's in your own name, whether it's joint, whether it's in the trust, that matters. And then corporate or partnership ownerships, and then custodial accounts, those are like accounts for kids, grandkids, and stuff like that. So what type of accounts are there? Financial, retirement accounts, real estate, right? These are the different types of assets there are. Life insurance policy, business interest, personal property, and digital assets, okay? So all of these things should be owned a certain way. So financial accounts. All of them, if you have a trust, and I'm assuming everybody here has a trust, and if not, maybe you need to consider it, and maybe not, right? But there's no reason your financial accounts, your bank accounts, your investment accounts, taxable accounts, there's no reason any of them should be outside of your trust. Every single one of them should be in your trust, even your checking account. Now, I know some of you have heard the professionals, your professional barber, your professional, hairdresser, your professional donut shop person tell you that the checking account should not be in the trust. They're wrong. It shouldn't. And I'll tell you why they're wrong from an administrative standpoint. Let's say you have $5,000 in that checking account when you pass away, and it's in your name alone. Okay? It's probably going to cost your family $1,500 legal fees to get that into your trust. Right? So you're going to not willing to take your family's money. Right? But is it cheaper for you to put it in the trust while you're living, or have you put it in after you pass away? It's cheaper for you to do it while you're living. So do it. Do it. Real estate, retirement accounts. Retirement accounts are tricky. Generally speaking, people will say with retirement accounts is that you designate beneficiaries. So, my dad died. He had retirement accounts. We have language in his trust that would allow those retirement accounts to see minimal tax implications if the trust was the beneficiary. Not all your trusts have that in it, okay? It can, but not all of your trusts have that language in it. And if you want to know if it is, make an appointment and they'll tell you, okay? So there's language you get to minimize the tax implications of the trust being the beneficiary of the retirement accounts. I have 2 special needs sisters. Okay? Disabled sisters, 2 special needs sisters. They received, because my dad transferred the beneficiaries of that account into the trust. Later on, somebody at the financial institution convinced him that he should take it out of that designation and designate it individually to the 6 kids. 2 of which are special needs. Bad, right? So, the point is, there's a possibility and a chance and an opportunity to direct everything to the trust. Everything you have to the trust. Namely, trust as the beneficiary on accounts and things like that. Now, in order to do that, you need to make sure that language is inside your trust to minimize any tax implications of those retirement accounts. But suffice it to say, is life dynamic or is life static? It's dynamic, right? It changes, constantly changes. Is there any guarantee that you're going to die before your beneficiaries? No, right? Or is there any guarantee that any of your beneficiaries will not become incapacitated either during your lifetime or at the point of your death? No. So why not have everything flow through the trust if it can? Because you've sat down, created a situation that provides for all the contingencies. If this child passes away before me or during this administration, or if one of them becomes incapacitated, right? All of these ifs. You've provided for those contingencies in your estate plan. Why have anything go outside your trust? I don't understand. Why? If your trust is properly prepared, everything could flow through your trust and be protected by the provisions that you've had put in your trust. So retirement accounts, real estate should be owned by the trust, unless it's owned by a business entity, right, like an LLC or something like that. But then the LLC should be in the trust, right? That's the business interest. Life insurance policies, the trust can be a beneficiary of a life insurance policy without any complications. All right? So why are there some people that say don't make the trust the beneficiary? Well, there's a specific carve-out for life insurance policies in the law that says that if I have a creditor, let's say a lawsuit is filed against me, and then I die in the middle of that lawsuit, and that lawsuit, my estate or I lost, so my estate owes somebody money. Well, if the life insurance policy goes to my trust, those people can collect that money from the trust, if it goes to my trust. But if the policy goes to my kids, they can't collect it from my kids, right? So there's a little bit of protection if the beneficiary is somebody other than my estate or my trust. But we can also get around that because sometimes people put in their trust a trust for their kids. So we don't have it go to my trust, we have it go to the trust for my kids. And we get around that, but it's still being protected by the trust. So in other words, there's ways to get around this stuff. You just need to make appointments if those things interest you. Personal property should all be owned by the trust. Digital assets can either be owned by the trust or perhaps the trust can be a designee, but you have to look at the specific company, the digital asset company, or even the social media, how to deal with those things, okay? So from a standpoint of administration, right, what we should get out of what we've just gone over is everything should either be owned by the trust or possibly directed towards the trust. Because that set up all your contingencies. Again, like the 401k, going to two of my sisters who have special needs, right? 100% disabled, right? Both of them receiving government benefits, right? So from that perspective, it kind of upsets the plan to provide for them and them not losing any government benefits by having something go directly to them. And so how things are owned and how things are directed is very, very, very important. So I think that's really what we get out of this. Now, defending legacies. I didn't bring my water up. Defending legacies. That's all about, no, it's all right. That's all about the family and how they're getting along, right? Or who's in charge and how they're dealing with everything and whether they're doing it correctly or incorrectly. Because in an estate, the defending legacies is really about the estate. So we've gone over some of the things, just put it this way, we've gone over some of the things that trustees have to do, right? Just briefly. So if the trustees don't do those things, right? Or if there's somebody who's being difficult, the beneficiary is being difficult, how are those dealt with? Again, it's part of the legal process. Whoops. So, any of your kids ever get in fights? Wait, first of all, how many of you have kids? Just one or two? Okay. Okay, how many of you have parents? Only a couple more. The rest of you are clones, right? Okay, so from that standpoint, when parents are alive and the kids get into an argument, who breaks up the argument? Parents, right? And so then it's a matter of, if the parents are no longer there to break up the arguments, who breaks it up? The judge, right? And so that's essentially the idea of defending legacies, right? The judge steps into the place that the parents used to take. I mean, if you think about it though, some of you probably have adult kids. I mean, they have families of their own and everything else. And if those kids get into arguments, who steps in? Who helps? Usually mom or dad, right? They're talking to them, trying to bring them together and stuff like that. And so that's part of the issue. And so when they're no longer there, then somebody else has to stop in and take over that role. Well, what happens, right? Well, how do we come into this situation? Well, we've got it up here. Poorly drafted or worded documents. So does anybody here have errors? Raise your hand if you have errors. Okay, so none of you have errors. How do I know? You're all living, right? You don't have heirs unless you're not living. So from that standpoint, and that's kind of a point with regard to poorly drafted or worded documents. And who are your heirs? If I say heirs, who are they? Your kids, also your grandkids and great-grandkids. And so if I was an attorney drafting your document, and you said to me, you wanted it to go to your kids, and I wrote heirs, who's it going to go to? All of them, yeah. Everybody below you, right? Everybody in your bloodline below you. And so would that be a correctly, accurately drafted document or a poorly drafted document? It'd be poorly, right? And so from that standpoint, we sometimes run into that type of a situation. And so I've been in court several times where errors had been used in a situation where it was, according to the kids, right, only supposed to go to the kids. And going into court to getting clarification and an order from the judge saying, yeah, it goes to the kids. And if you think about it, sometimes from a trustee standpoint, and by the way, in one of these situations, the trustee was a professional trustee, it was a bank. So you put yourself in the place of the bank, all right? Or just as a trustee in general. If they just made a distribution without going to court to the kids and not giving nothing to the grandkids or the great-grandkids, do you think they feel safe about not being sued? No, right? So they have to be proactive and they have to go into court and they have to ask the judge to give them an order to, give them an order to make the distribution only to the kids rather than to all of those other family. Documents can be incomplete. I've seen this in trusts. I've seen 3 kids, 33% to this, 33% to that, and 33% to the next. What's wrong with that?
Where's the other one?
Exactly. Who gets the other 1%?
Yeah.
Now, logically, you would think, well, just get split equally between the 3. But again, you're the trustee. You want to be liable for that? Right? And it may not be so bad if it's a $10,000 estate, 1%. What if it's a $10 million estate? Right? Or a $100 million estate? Right? Do you want to be responsible for that 1%? No. Right? So part of it is are the documents complete? Out-of-date documents? I mentioned retirement accounts and having language inside the trust to minimize the income tax implications of distributions to a trust of an IRA. How many times do you think the IRA laws have changed over the last 30 years?
At least 30 times.
You know, right, exactly. They've been changed multiple times over the last 30 years as it relates to how do you treat retirement accounts. Right? So something that was prepared 10 years ago, or 15 years ago, 20 years ago, relying on that retirement language in there can be completely different today. Right? And so sometimes the dates of the documents are just out of date. And I know none of your kids are greedy, but sometimes that happens. Right? Sometimes they're greedy kids, and sometimes the greed is just out of greed. Right? Or sometimes the obstinance is just out of greed. But other times, it's out of just so he's fighting with himself, then he needs more help than any attorney can give him. Right? But I had 5 siblings and we fought. Verbally and physically. Right? We fought. And so sometimes, and because you have older siblings and you have younger siblings, and again, the older ones always think they're right and in control, right? And look at her, she's saying she is. And, right? You've got this tension within the family, which again, because the parents aren't there, can cause further issues, right? And so sometimes they're there. So who do we represent? Trustees, fiduciaries. When beneficiaries are causing problems, and we also represent beneficiaries when the trustees aren't doing their job. right? Beneficiaries, they can be impatient, right? It's give me the money, show me the money, I want it now. So, unthankful, absolutely unthankful, right? Because it's theirs at this point, it's theirs, give it to me, right? We don't want to wait for anything else, and you're taking too much time, and you don't have to do all of that legal stuff. And again, the unresolved conflicts. So an unresolved conflict, my mother used to say of me that, James, I don't mind you making financial decisions for us, but for some reason all of my siblings thought I was the favorite one. I don't know. I mean, that's what she said at one time. And so, but if that was the case, then think about if all of the other kids thought that I was treated differently than them, and then I was in charge of everything, would there be a little resentment? Yeah. So it makes sense then that taking that into, that's something that can happen. Or if my oldest sister was the trustee, and she lives in Australia, so she never was. But if she was, right, then the issue of her always being in charge and stuff like that could have brought up issues also, right? Or if it's the youngest one. So, like when you're in a family of 6, and the first one was born in 56 and the last one was born in 68, right? Those last couple of them, they were treated different than the first few, right? Mom and dad either matured or they just got softer as they got older. One of the two, right? But there's a different treatment. And so then one of the younger ones, then that can cause some resentment from the older ones, right? Just because, they were always favored, or whatever the case may be. So, unresolved family conflicts. Trustees, again, what is one of the most compelling problems in any relationship? If there's a problem in a relationship, why is there usually a problem?
Communication.
Or lack of, right? Not giving enough information, right? Because we're wired, right? Generally, so again, if I'm the trustee, you're the beneficiaries, and you're all at my dad's funeral. I saw you there, right? And you're all beneficiaries of his estate. And I say to you that, hey, I'm going to get in contact with you soon. So a week goes by and you don't hear from me. A month goes by, you don't hear from me. 3 months go by, you don't hear from me. Right? 6 months go by, you don't hear from me. Right? I know all of you are assuming I'm doing what's good for the trust. Right? And then I go out and I buy a new car. Right? And then I go on a trip. And you still haven't heard from me. But in your mind, I'm still doing all the right things. I'm not using any of Dad's money improperly. I'm not doing anything right. No! You're thinking the exact opposite at that point. You're thinking, what's he doing? He's using all that money for himself. Right? There's not going to be anything left. And we're not going to get anything. Right? So communication is vitally important when you're a trustee. You have to constantly communicate. And so when you don't, right, it makes for a bad situation. So being the right fit as a trustee. So anybody good with numbers? Right? A couple people here good with numbers? You might be a good trustee. If you don't like numbers, you may not be a good trustee, right? And I'm not saying that all people who are good with numbers would be good trustees. I'm just saying you might not, right? Are you somebody who wants to get their hands dirty and get the work done and get it done? You might be a good trustee. You have difficulty making decisions, right? Are you so emotionally tied to something or a parent or something that you can't operate? No, you may not be a good trustee. So it's a matter of fit. Not everybody could be a trustee. So for instance, using it in a different scenario, my mother used to say of me, you know, again, I don't mind you making medical decisions. I mean, financial, I don't want you making medical decisions. Because at one point, why did she say that? She was afraid I'd be making a medical decision based on finances.
Yeah.
Well, does it cost less to do it? Or does it cost less to let her die, or does it cost less to save her? Right? You know, so there's those kinds of concerns. So in her mind, you know, making medical decisions wasn't a good fit. And that's fine, right? But it's got to be a good fit. It's got to be the right person. It can't be just the oldest one. They may not be. It can't be the youngest one. It's got to be the right fit. So if it's not the right fit, they're going to fail. So if it's not the right fit, you're setting someone for failure. And so, trustee, of course, in representing beneficiaries, if the trustee is not doing their job, right, and using the assets as their own, that's a problem. Influenced, incompetent, trustworthy. Yeah, so sometimes there have been several situations where, you know, okay, we'll just use this as an example. So during the last year or two of my dad's lifetime, I was going up there and seeing him a lot. And what happens if all of a sudden he made a change to his trust and he disinherited the other 5 and left everything to me? Right? Or you're all beneficiaries of that trust. He disinherited you and gave it all to me. Would you have a problem with that? Would you think something wrong happened? Yeah, and it may have. And maybe it didn't. But it may have. Right? But if I had that kind of influence on them, and sometimes the influence is this bad. Dad, I'm going to throw you out in the street unless you change your trust. Right? So I mean, if Dad's living with me, and I threaten to throw him out on the street, you know, so yeah, you can have influence over that. You know, make him do something he wouldn't have normally done, and so there becomes a problem with that. So, different cases that the law office handles, proper trustees, right? Determining who the trustees are. Like sometimes there are disputes. So earlier, Victoria talked about not handwriting inside the documents. So think about it from my perspective, right? I'm looking at a document that somebody has scratched something through. And it's initialed and it's dated or it's signed or whatever. And I'm looking at that. How do I know who did that? I don't know. So now, right, you take that to the bank or somebody else. Let's say it's somebody crossed out who the trustee is. Right? We crossed out Chris's name and put in Stephen's name. Handwritten in, dated and signed. Now, you're the person working at the bank. You see that, and I bring the trust, I'm Stephen, I bring the trust document to you and say, here, I'm the trustee. What are you going to do? It's got an initial or a signature next to it and a date. What are you going to do?
You're going
to push it back across the table and say, give me a judge's order. Right? Give me a judge's order. So, don't do it. Or, I've seen this. Somebody X'd out a page. I've seen the judge go, whatever that line touched are the words we're going to take out. That's the case. Right? Yeah. And so, you know, so the law doesn't say you can't, like, cross things out. But the question always becomes, well, who crossed it out? Right? So that's why it's like, you don't do that. Or if you're going to do it, I always say you do it in a temporary manner. And you get into the office and have a formal amendment done. Prepared and signed in order to verify your wishes and intent. Asset dispute against what? You know, sometimes it's a matter of, hey, I've got 4 pieces of property, 4 kids, each child gets a piece of property, but during my lifetime I sell one. I don't change my trust. right? Well, does that mean that one child doesn't get it? Anything? Because that property's gone? It depends, right? But there could be disputes and assets. Also, it could be a matter of who owns the asset. Sometimes, the asset, like we're dealing with one right now, where there was a trust done in like 2000, and rather than restating that trust, they did a whole new trust in 2015. There's a piece of real estate still owned in the 2000 trust, but no copy of the trust. So now we've got to go into court and say, and this is an asset dispute between inside the family, between one trust and another trust that we don't even have a copy of. And we have got to go into court to say, well, that piece of property is supposed to be inside this trust. So, asset disputes. Investment of assets, whether it's done properly, or trustees doing the right thing or not, removal of trustees when they're not doing their job. And their job is everything we went over during the administration portion of this, and getting assets into the trust that were left out. It's not uncommon for somebody to create a trust and think that once they've done that, everything's in the trust. And then they fail to move assets into the trust at that point. And undue influence claims, and again, that's a matter of, me twisting your arm to do something you didn't really want to do. Also, in addition to that, contract disputes, elder abuse. And by the way, when I tell my dad, I'm going to throw you out in the street, and I think what is it, 65? Maybe I think it's, or is it 60? It's presumed under influence. I mean, elder abuse, if you're taking advantage of somebody over 60 years old. Personal injury cases, wrongful death. Elaine has a network of attorneys that she's worked with over the past, and from that perspective, if you call and you have an issue, if our office can't handle it, we can probably get you somebody to handle it. Somebody that you can talk to. So, with that, that's the end of the educational part. And now it's a matter of who should I refer. And I say everybody, right? I don't care. I'll take anyone's money. So your friends, your family, just for special interest groups, book clubs, social clubs, what do they call those things? I don't know, like Rotary and Kiwanis and those kinds. Your church, some of you may have come as clients from church seminars. You can refer your neighbors. The other thing too is remember those of you who are Access refer people in and they get consultations for free, the 2 hours and everything like that. You can even refer your enemies. I'll take their money too. This is, I look at it from a standpoint of, and you don't have to believe the same way I believe, right? But I believe that there is a sovereign God in control of all things. In control of everybody who came here, right? In control of the situation, everything. And so when somebody sits on the other side of the desk for me, I believe they've been appointed to be there by God. But not necessarily to become a client. They may not, right? And I don't know whether we're going to be able to help them or not. But I do believe they've been to be there. And so because of that, I treat everybody in the manner that they should be treated for that. Had a gentleman come to me several years ago, but some of you may have heard the story. He's come to me several years ago where he had a child, and the child passed away. A young adult, 20-something-year-old. There's serious parts, there's emotional parts, and then there's also laughter. There's sadness and laughter. And after the meeting, he got up and he said, "James, I haven't laughed in 4 months." And from a sovereignty standpoint, who's to say that's the whole reason he came in? I don't know. He never became a client. There's nothing for us to do. So I don't know why somebody's sitting across from us. I really don't. But I say, you know, if we're treating you well, if you think we're doing our job, we're for them. They come in, they're supposed to come in. They don't come in, they're not supposed to come in. But for time and attention, I thank you for being clients of ours. And we're here for you, you're not here for us. And I want you to remember that. You're the boss. We're not the boss. Okay? You're the boss, we're not. You still have an opportunity to make an appointment. There's a lot of stuff that we went over today. And absolutely, there's something we went over today that you need to address. Right? I mean, even if we're talking about the retirement account issues and stuff like that, the beneficiary, naming your trust as the beneficiary of retirement accounts. And so, they're still up there, book an appointment. What else do we need to do? Anything else? Oh, David wants to give away some stuff. So if you leave, you can't get it. And
So we had a special drawing. So in that drawing, we had a number we drew, and that number ends in 538.
I got it right here.
Oh, you do? Steven, right? Right, we got 2 gift cards for $150 worth. So Joey's good food. And that basically is it. Have a wonderful day.
Where would you like these?
Oh, did I make sheets? You can just drop those off the table back where the ladies are right there. Just drop them right there. Any other questions? Feel free to ask them.
Very similar.
Sure, I have this. Plus the ones in there. Okay, I've got